Too many times we are called upon to prepare a power of attorney form, a legal document that gives another person the right to act on your behalf, representing you in all aspects that are stated in the form. This form may be a necessity in many cases, especially during the 2020 COVID-19 pandemic, but there are certain implications that the party who gives the form and the party who receives it should be made aware of. This is Juliana Tu, and that is going to be my educational subject for this video. But first, let us do the disclaimer. The information contained in this video is only intended to provide a guide in the various transactions to which the information is applicable. No representation is made as to the legal validity of the information or the adequacy of it in any specific transaction. The information contained should only be used after consultation with your own legal and financial counsel. So, are you going out of town? Do you live too far away? Perhaps there's a difficult illness. There has to be a good reason why a person who is selling or buying an asset would be giving away control and not keeping a close look at what is happening. When the escrow agent is called on to prepare this power of attorney form, the reason should be given, and usually there's a disclosure or an amendment that is signed in conjunction with the form, stating the why, and also releasing the escrow agent or the title insurer of responsibilities for relying on this form in the transaction. Now, there are a couple of power of attorneys. The general power of attorney and the special power of attorney. These are two types that are usually used in a real estate transaction. And then there is the durable power of attorney, and this one is usually used for health and illness issues. So the discussion today will be concentrated on the first two, as they are most often used in real estate transactions. So what are the differences? The general power of attorney is an all-encompassing form, allowing the attorney, in fact, it's the person who is being given the power of attorney, to act and handle anything for the benefit of the appointor, who is the person who's actually giving the power of attorney out. This would include real estate and other business dealings, even health directives. Now, the special power of attorney is limited to certain powers and certain events, and those events have to be clearly stated in the body of the document. In short, this is the preferred document that we like to use when we're handling a real estate transaction. And in cases of borrowing money, the lender is going to be insistent on using this type of a form. Now, there is going to be language in both forms that are going to be very important and should be incorporated in there. Giving and granting unto said attorney, in fact, full power and authority to do and perform all and every act and thing whatsoever requisite and necessary to be done in, about the premises, as fully to all intents and purposes as to the undersigned might or could do if personally present. So, as you can see, this is very strong language. And this language highlights the cautionary steps that we need to take when giving or accepting a power of attorney. So here's some guidelines. I have a longer article that is written, a link which is in the description below. But these guidelines, I hope, will give the consumer and the general public some idea of what they should think about and what they should follow when they're giving away their rights. First of all, are you absolutely sure that you are not going to be able to be present to sign, or are you doing this as a convenience? Certain parts of the real estate transaction, particularly the contract and any changes to it, should be signed by you, which means that you are aware of the terms and transaction and the changes that are going through. You need to put a time limit on the power of attorney so that it does not go on forever. For escrow and title insurance purposes, a power of attorney over 2 years old will probably not be accepted unless there are certain approved circumstances. If it is an older power of attorney that is used, the attorney, in fact, may be asked to sign under penalty of perjury an affidavit that states the power of attorney was not revoked or terminated. Remember that penalty of perjury is a sworn statement that says the statement is true and correct, and if the person who is saying this is knowingly making a false statement, he will be guilty of a crime under the law. The appointor, as stated earlier, may be asked to give a separate statement that he is giving the power of attorney of his own free will and is aware of what the document does and will release the liabilities of the entities from reliance on the document. In a real estate transaction, there's probably going to be a statement right on the power of attorney that says that this document is for the purpose of the sale or the purchase or the refinance of the property located at such an address. And it should also state to lease, let, demise, bargain, sell, remise, release, convey in trust, and hypothecate. This will allow the attorney, in fact, to transact the real estate related business. You must not give the power of attorney to someone who is intimately involved in the processing of the transaction. For instance, the real estate, the agent, the escrow agent, or the loan agent. Now, this is important. Only an individual can give a power of attorney. If this is a trust, or a corporation, or an LLC, or an estate, or any entity other than an individual, this member cannot assign their corporate rights by power of attorney. This is something that many people don't realize or they forget. Those rights and responsibilities in a corporate entity must be assigned within the entity itself by a corporate resolution, with a vote by the board of directors or the other managers of the LLC. An attorney, in fact, it is important to remember, cannot sign any document that will give himself consideration, compensation, or interest. This is called self-serving. For an example, let's say that James Smith is an attorney, in fact, for his wife, Jane Smith, and he proceeds to sign a document that gives all the proceeds to James Smith himself only. That is an absolute no-no when the escrow agent sees this. In a general power of attorney, if the appointer becomes mentally incompetent or dies, the power of attorney becomes invalid. A perfect example of this can be seen in my Think Escrow educational channel, Escrow Stories from the Trenches. The topic is called Life, Death, and Escrow, a link which can be found in the description below. Now, you should also give the power of attorney to the escrow agent as soon as possible in the transaction, because your escrow agent is going to have to review it, and it has to be reviewed by the title company and the lender, especially if the lender is going to need to have this for signing of their own loan documents. Lenders have been known to request an explanation letter from the actual borrower regarding why they are giving a power of attorney. We have had lenders demand that the title insurance company issue a letter acknowledging that they will accept the power of attorney and will insure the transaction. It is a sign of a breakdown of trust and the fear of fraud when demands like this are given. In order to insure the transaction using a power of attorney, the form has to be signed in the presence of a notary public by the appointor, and the document has to be recorded in the county recorder's office where the property is located. Once the use of the power of attorney is completed, it would be a good thing to revoke it by signing and recording a revocation form. This form can be found in the forms link that I have in the description below. Before I finalize this section, let me go back and briefly mention about the durable power of attorney. You will find this form normally made a part of your will or your trust, and it has specific language that is used for the handling of assets and the financing in the event of your illness, accident, or if you are incapacitated, or if you become mentally incompetent, something that an ordinary general power of attorney form cannot do. It also will allow the attorney, in fact, to make decisions regarding your medical and the health care. Sometimes, though, if it is crafted with correct language, this durable power of attorney can also be used in handling matters of real estate, but it has to be reviewed by the escrow and the title agent. To summarize it all, for the attorney, in fact, who has been given the full power and authority to act for another person, it is important to remember that this is a very serious responsibility and that he could be fully responsible if any problems or lawsuits should arise due to his acts. For the appointor, and that is the person who is giving the power of attorney, some words of caution. Do not lightly give away your responsibilities. Once given, be sure you keep yourself in the loop at all times. After the need has been satisfied, revoke the original document. My t-shirt for today. The rock group Crosby, Stills, Nash. And as you can see it, here's my t-shirt. This is after Neil Young had left. I attended their concert tour in 2012, and like my kids say, hey, it's not bad for old fogies music. This is Juliana Tu. If you have found this article helpful, then I hope that you will like me and also subscribe to my channel. I look forward to seeing you in my next video.